హలో! హలో! రవి బ్రో.
చెప్పరా?
నువ్వొకసారి మాట్లాడు.
వినిపిస్తుందా?
ఆ!
ఆ!
సరే. ఓకే.
Hello.
Good afternoon, participants. We'll be starting in another few minutes. Good afternoon, participants, and welcome back to the last law session 2-day online module on the new criminal laws. Yesterday, we had a brief overview of the changes, modifications, additions, deletions in the BNS. And as all of you would have observed, the changes in the other sections are minimal and do not actually affect the way we invoke these sections for various offenses. So the mens rea and the actus reus components and the ingredients more or less remained the same. We also spoke about two important additions, that is organized crime, the concept of organized crime and the concept of terrorist act in the general penal code, that is the Bharatiya Nyaya Sanhita. Though these two concepts are not new to the criminal justice system in India, they are new to the general penal code. So now they will be more widely used by various state, local police forces. In the morning, we had covered the concept of organized crime and petty organized crime and various nuances related to these two offenses, types of offenses in the Bharatiya Nyaya Sanhita. Today, right now, we are going to talk about and cover the concept of terrorist act, where, like I told you, it is already existing as a provision as part of the UAPA Act. Uh, by adding it to the Bharatiya Nyaya Sanhita, the scope of its implementation or use has been widened. But before that, we need to be able to understand what exactly constitutes a terrorist act. What are the other provisions available in Section 113 which relate to punishing a person for conspiring or abetting or attempting or advocating or inciting or facilitating or even being involved in any preparatory act which is preparatory to the commission of a terrorist act. Whoever organizes camps, uh, whoever is a member of any organization which is involved in a terrorist act, whoever harbors, conceals, or attempts to harbor or conceal are also declared as offenses. So you would see a similarity between these concepts in organized crime as well as in terrorist act. To be able to effectively implement this provision, it is necessary for us to understand how the provisions of the UAPA are being invoked, what are the comments by various courts and other judicial fora, what are the challenges in implementing these provisions related to terrorist act, and as a good investigating officer, what are the do's and don'ts that have to be kept in mind. So we have the best person to delve into these topics, and it is my honor to introduce Shri V. Vikraman, IPS. He is currently the Deputy Inspector General of Police, National Investigation Agency, Hyderabad. He is an IPS officer of the 2010 batch, born on the Tamil Nadu cadre. As SP Viluppuram district, he has seized more than 500 illegal country-made weapons in Kalvarayan Hills and prevented major illegal activities. As SP Tirunelveli, he controlled the communal murders and caste clashes. As Superintendent of Police, Q Branch CID, the officer has collected several sensitive and valuable intelligence on Maoists, LTT, human trafficking, etc. He has played a crucial role to establish the office automation and computerization wing, implementation of the e-office application in 7 commissionerates, 31 districts, 4 zones, and 11 ranges of Tamil Nadu. As DCP, he ensured effective implementation of cyber cells set up to prevent online frauds. Since May 2021, he is working in NIA at the branch office Mumbai and the branch office Hyderabad. He has handled various sensitive cases, including the rupees 21,000 crore Mundra port case, the PF5 conspiracy case, of which he is the chief investigating officer, and which resulted in the banning of the organization in 2022. He was awarded with the Union Home Minister's Medal for Excellence in Investigation, and presently he is the DIG supervising all the NIA branch offices of South India. So I hand the session over to you, sir. And as usual, I request the participants, in case they have any questions, please type it in the chat box, and we'll get it. We'll get to it as and when feasible. Thank you, sir.
Thank you, Abhinav, for a wonderful introduction. So, the lecture, I have divided it into three parts. One is the Terrorist Act as defined under BNS, and then I will be discussing UAPA Act for obvious reasons, because the BNS Act section 113 draws majorly from the provisions of UAP Act. So now the probable reason for including the special acts into the main act is that the officers in charge of police stations, the district superintendents of police, should not shy away from registering sections under these provisions only because they are part of special acts. That should come in the mainstream. So what I'll do is, first we'll have a small discussion, brief. We'll see the definition of Terrorist Act under BNS and UAPA Act, and I will also be giving you comparison between BNS and UAP Act. That means what are the similarities and what are the functionalities or what are the features which are available in UAP Act, which can again be utilized by the state police. See, again, I want to clarify a point, that only because section 113 is invoked in BNS does not prohibit you from using the other sections of UAPA Act, which are very handy in terms of handling terror situations. So now, moving ahead with the presentation. So this is how section 113 Terrorist Act, what does it say in BNS? Whoever does any act with intent to threaten or likely to threaten unity, integrity, sovereignty, security, and economic security of India with an intent to strike terror or likely to strike in the people or any section of the people in India or in a foreign country. This is as it is defined in section 15 of Unlawful Activities Prevention Act. So as far as the definition is concerned, there is no confusion. It is almost the same. In fact, it includes the updations that have happened in the various amendment acts of the UAPA in 2008, 2012, and 2019 also. So now the second part of the definition, section 113 clause 2, what does it say? By using bombs, dynamite, or other explosive substances or inflammable substances. So what are the materials which could be used in the commission of this terrorist act is also falling very close to the definition which is provided in the UAP Act. So again, section 113 clause 2 definition is very similar to UAP Act. Now, and what does this terror act cause? Death, injury to any person, or loss of damage or destruction of property, disruption of any supplies or services essential to the life of community in India, damage to the monetary stability of India, damage or destructions of any property. So if these ingredients are there in an offense, then you can register a case under section 113 of the BNS Act. I hope that is very clear, the definition section of what constitutes a terror act. Now, if you see the punishment, so if this terror act has resulted in the death of any person, it will be punished with death or imprisonment for life. Similarly, if in any other case, so it's not necessary that all terror acts there should be death. For any other offense or for any other outcome, they will be punished with imprisonment for a term which shall not be less than 5 years, but it can extend up to life imprisonment and shall also be liable to fine. Again, you see that this is very similar to what is defined in the UAP Act. Now, section 113 also gives you a clarity on who can actually register a case. Officer of the rank of superintendent of police shall decide whether to register the case under this section, that means 113 or the UAP Act. Some participants are saying they're not able to hear. That's okay. Okay. So फैसला कौन लेता है? Superintendent of SP and above will decide whether a particular terror act be registered under 113 of the BNS or under the provisions of the UAP Act. Now let me also show you what UAP Act says. UAP Act also defines terrorist act and what are the ingredients of the terrorist act. That means by using bombs, dynamite, you can compare with the previous slides. You will find out that the definition under the BNS and the definition of a terrorist act under UAP are pretty much same. So which means so far whatever investigation was done by specialized agencies, be it the state ATS or be it the NIA, will now be done by officers in the police station, or it could be in the district. So there is a huge burden on all of you to understand this act properly and then to perform investigation. Now, when I talk about terrorist act, now I wanted to also show you some scene of crimes, which in all this entire presentation, whatever photographs and whatever material I'm showing you is all from NIA investigation. This is Dilchuk Nagar bomb blast site, which I'm showing you. So now this is a typical SOC that you may have to tackle. This is a bomb blast site. Now in this bomb blast site, let us not go into the nitty-gritties of the case because that is not the point I'm trying to discuss. But this is a typical SOC. The next slide also you see. So this is how this is what you can expect from a site. Now, what do we need to do in order to preserve the scene of crime? First is, while you are arriving at the SOC, you will be the first responder. You will have to first preserve the area. Preserve the area as in, if this is how the post-blast scene looks like, this is how it should be preserved till all the material evidences, searches, and other things are conducted in the SOC. Till then, there should not be anybody disturbing the scene of crime. Then, of course, those who are injured should be given medical treatment. And whoever is there, you must understand that the eyewitnesses you are going to get only in the first 1 or 2 hours of the blast. Those who have seen it in their eyes, you will not get them later on. So you should not lose this golden hour. Try to identify people who have seen the site and note down their names. I'm not saying you sit and make a detailed statement then and there, but at least you identify the witnesses and then you can always summon them later on. But this should not be missed at any expense. Then comes the most important part of recording. Recording means a typical SOC, it should be recorded as it is. Video recorded, photographs properly taken, rough sketches should be drawn, clearly delineating the entry and exit points of the suspects. We should not miss out on these key aspects because later on there is no way you can reconstruct the scene if you have not done it in the first 1 or 2 hours. So recording of this scene of crime is a very important ingredient in dealing with any terror act. And then if at all there are any bodies in a blast, unfortunately there could be some dead bodies. Please record them, photograph them, and the distance of the object, such as burnt pieces of explosives or IED devices, take photograph of them, and also measure the distance from stationary objects. It could be a wall or it could be some statue, any permanent stationary object. Try to measure the distance between the objects that you are going to seize and from the stationary objects. So this way it will be easy for us to understand how much gram or how much material of explosive substance was used in the commission of the crime. Later on, it would be helpful. Then the most important thing is searching the SOC. Now, you can take the help of the forensic experts, forensic assistants, pack whatever you feel is suspicious. It could be some nails, or it could be projectiles, or it could be burnt remnants of explosives. Anything that you feel will help the case to err on the right side is the best suggestion. So seize them properly, and after seizing them properly, including soil samples from the blast site, including fiber samples, biological fluids, these should be properly searched, seized, packed, and forwarded. But ensure that the chain of custody is not broken. Now, once you seize it, immediately it should go to your malkhana, where every property, it should be given a label, and then it should be forwarded to the court, and from the court to FSL. In some states, in South India especially, the courts actually take the property and forward it. Whatever is the procedure followed, please ensure there is no undue delay in forwarding of these seized material. In case you are seizing any mobile phones strewn around, it could even be the mobile phones of suspects, please forward it to your FSL. It could be in central certain or any FSL accredited labs, and try to obtain the IO copy. Now, all these things are not actually part of only terrorist act. ऐसा नहीं है कि सिर्फ टेररिस्ट एक्ट BNS में ये सब करना है, बाकी केसेस में नहीं करना है. It applies equally well to everything. But in a terror act, if you miss, the stakes are high. That is why I am reiterating these points. Now, moving ahead, see, these are some blood samples. As of when you go to the SOC, you will not know whether the bike was actually used as a projectile or whether it was used for carrying. So you should always exercise caution. Now let us look at the commonalities. Section 113 clause 3 is nothing but section 18 of the UAP Act, which criminalizes conspiracy. Now, punishment for conspiracy, now I have put it side by side so that you can see and understand the similarities. So whoever conspires or attempts to commit or advocate, abets, advises or incites. Now, इसमें हर शब्द का अपना अपना अलग meaning है. So it's a very umbrella, broad terms used. So therefore, what I'm trying to say is, whether somebody advises or somebody abets or even incites, they can be booked under section 113 clause 3. Now, the problem with section 18 is, it is so easy to say that accused number 3, 4, 5 are all co-conspirators. You may even get oral witnesses to prove your point, but getting corroborative material evidences, digital evidences, you will have to slightly dig deeper. Similarly, section 113 clause 4 is nothing but 18A and 18B combined together of UAPA. In section 18A, punishment for organizing of terror camps, and 18B, punishment for recruitment of any person or persons for terrorist act. Both have been clubbed together under section 113 clause 4. And what is the punishment? For a term shall not be less than 5 years, but which may extend up to imprisonment for life. Now, a word of caution when you are dealing with conspiracy sections, as I mentioned earlier, it is very easy. See, this one case where the accused simply told us, this was a case which we recently charge sheeted. In this case, the accused said that, sir, उनके घर पे explosive substance मिला था, gunpowder मिला था, and they had procured sulfur, potassium nitrate और चारकोल, वो सब उन्होंने अमेजोन से ऑर्डर करके घर पे इसको मिक्स करके गन पाउडर बनाया था, और ये गन पाउडर को टेस्ट करने के लिए उन्होंने टेस्ट ब्लास्ट भी कराया था. So now in the police custody, these accused said that, sir, we also did one test blast. Now, during the seizure of this explosive material, it was seized from the possession of a single person. तो उसके खिलाफ चार्जशीट करना आसान है, लेकिन उनके गैंग मेंबर्स को यदि आप 18 सेक्शन में यानी 113 क्लॉज 4 में अगर लेके आना चाहते हैं, तो फिर यू हैव टू गो अ लिटिल डीपर. सो व्हाट वी डिड वाज वी टुक दिस फेलो टू द टेस्ट ब्लास्ट साइट, एंड वहां पे टेस्ट ब्लास्ट साइट में जो भी सैंपल मिला था हमें, सॉइल सैंपल, that we collected, you see on the left side. But surprisingly, see, the luck favors the brave. So in this case, the FSL report tested positive for gunpowder, which means now whatever part of the confession would otherwise have been inadmissible, now it is proving against 2 or 3 more co-conspirators. So this is what I'm trying to say. You should dig a little more deeper. Similarly, section 18A and 18B, organizing terror camps. जब हम PFI के खिलाफ केस कर रहे थे, there were a lot of oral witnesses, and this organization was running terror camps. Basically, they were teaching young boys how to kill. मतलब चाकू कैसा चलाना है, इधर गर्दन में मारना है या यहाँ पे. So where you should strike so that people will die fast. These are the kind of training that was happening for the ultimate purpose of establishing a caliphate in India. Now, in that case also, there were overwhelming oral statements. जिन्होंने camp attend किया, they were coming forward and explaining to us, sir, ये सब पढ़ाया गया था. But then they did not have, they were not allowed phones also inside those camps. There was no way to record the proceedings, and they used to instruct that all the participants will switch off and deposit their phones. So how do you prove? But then, unless you have some corroboration, jahan pe they conducted all these things in the garb of a physical education program. Now, we went to the function halls, we went to the places where this happened, and luckily you see the name of Popular Front of India's name is there. So which means what the witness was telling us is not false, it is not untrue, and it is corroborated through a documentary evidence. So now you should understand that whichever section you are going to charge sheet, you should try to have 3 types of evidences. एक oral है, दूसरा documentary, तीसरा material. Now in this, you all will agree that the most flimsy is oral witness, because in front of you today, somebody may come and depose something, but tomorrow in trial, the same person may become hostile. So now, why NA has a high conviction rate is because we ensure that for each section, we not only have oral witnesses, but we also support that oral witness through documentary and digital evidences. As far as practicable, थोड़ा सा मेहनत करने से ये सब मिल जाएगा. Now, why nowadays what is happening is a lot of young boys are actually coming under the influence of social media preachers, social media handlers, online handlers. So Facebook, WhatsApp, Telegram, Signal, these are some of the common things. We have seen many more also. And then terrorist organizations also assume pseudo online identities. इसमें सबसे बड़ा प्रॉब्लम ये है कि अगर आप टेलीग्राम को या ऑनलाइन सोशल मीडिया वालों को लिखेंगे उनका जवाब इतना आसान से नहीं मिलने वाला है. They are not going to give you readily the details. They will say come through LR route or MLAT route, but they will keep on try to postponing it also. So now one more advice that I would give investigators is try to use social media proceedings as a tool. So when accused is in your custody, try to get a duplicate SIM of that fellow and try to download whatever is available in the cloud. That I'm telling you will have an immense potential to prove many of the sections you are registering, especially conspiracy sections. So this generally does not happen in police stations. That's what I'm saying. What the mind does not know, the eye does not see. So now social media extraction, any terrorist act worth its salt has an online handler, has VPNs involved, and has disappearing messages. So you are not going to get much from his phone, from the suspect's phone. But then if you actually download content from the cloud, then I think you will make a lot of headway. So these are some of the encrypted communications we have seen in NIA investigation. बहुत सारे ऐसे apps हैं जो encrypt कर देता है message को. Now, this is also one of the methods we use. See, these are some suspects. These are some of our persons whom we arrested in a recent case, and all of them knew each other only online. अब एक दूसरे को सिर्फ आवाज से पहचानते हैं. They don't even they have not even met even once. So which means one of the accused, he was continuously denying कि I was not that fellow. That online assumed identity is not me. So what we did, we actually blindfolded them and we asked each of them to speak. After that, we called the fellows who were part of the group and we asked them to identify. They readily said, "Sir, ye wahi hai." So that is how we were able to pinpoint this fellow. So I am saying to prove certain sections of the BNS, you will have to go a little deeper. Now the other comparisons, section 20, being a member of a terrorist gang is same as section 113 clause 5. Similarly, punishment for harboring an accused is nothing but 113 clause 6. And punishments for holding proceeds of terrorism. That means whoever knowingly possesses any property derived or obtained from the commission of a terrorist act or acquired through the commission of any terrorist act shall be punished with imprisonment for a term which may extend to imprisonment for life or shall also be liable to be fined. So now this is the commonalities between the two acts. So far, any questions? I'll just wait for a minute.
So here, if I may intervene, sir, regarding the last point you have done, which is any person who is a member of an organization which is involved in a terrorist act shall be punished with a certain term. So I am sure that in some of the cases that you've investigated, especially against the larger organizations that we've spoken about, many would claim that they acted in their individual capacity and it was not an organization which was involved in the acts, but an individual. So how can we overcome this particular?
So देखिए ऐसा नहीं है कि terror act should be performed only by terrorist organizations. So now central government declares some of the organizations, say LTT or CPI Maoist organization, as proscribed organizations or terrorist organizations. But then some people who have no backing, they may not even have a 41A case against them or a simple theft case also, may join together and may do a terror act. So for doing a terror act, you don't have to be a member of a proscribed organization, yani banned organization. So you can actually be a member of common public, and if you do a terror act, you will be punished under section 20 also for being member of a terror gang. Gang is different from terror organization. That is what I'm trying to say.
We can take some of the questions that have already been written in the chat box. So There are three questions, which I think the first, what can be the intent of the legislature? I don't think we need to cover that, or do you want to
No,
cover it?
intent of the legislature could be to mainstream terror activities, because this is what I feel. All along, whenever there is a bomb blast, the SHO or the police station could probably say, no, this is not my cup of tea. But it's not so. And I feel, slightly digressing from the topic, BNS also criminalizes rape against minor children. So which means there will be POCSO Act is also included in BNS. So the intent of legislature, it appears that all these special acts should also be part of the main act, so that our officers don't shy away and it becomes a matter of routine for them also.
Next, I would like to ask regarding, once a decision is taken to invoke 113 BNS by the Superintendent of Police, and subsequently during investigation, the need for UAPA is felt, can it be invoked or otherwise?
See, there is one question asked by Mr. Jatinder Johar. So it says that in case a case is registered under 113 BNS, do we have to inform NIA? As of today, 113 is not a scheduled offense of
Yes.
NIA.
Yes.
The scheduled offenses of NIA are clearly mentioned, but then it will be a matter of time, in my opinion,
Yes.
that 113 is also made
Added.
part of
Yes, sir.
scheduled offenses. But then even otherwise, NIA can come into picture if you invoke. Now in the next part of the slide, I'll be discussing what is not in BNS but in UAPA. So when you start investigating a terror case, you will have to touch upon these features also, which means you will be invoking these sections and NIA will come into the picture.
Yes. So basically, that answers one of the questions, which is once the decision is taken to invoke 113 BNS, and subsequently need is felt for invoking UAPA, can it be invoked? The answer is definitely in the
Definitely,
affirmative.
yes.
And then once it is invoked, then Section 6 of NIA Act will apply, and all the other consequent procedures of UAPA Act will apply. So I think, sir, we can
Proceed
go
with the
on,
next.
and we can take this one question, which is more of an opinion, but on what material will the SP decide whether the case is to be registered under BNS or UAPA?
Now, these guidelines will be framed by different state police organizations. But see, sir, whenever a new act comes, it takes a while for it to settle down. So it's very difficult to comment on how SP would decide. Suppose if it's a small minor issue, I'm just guessing. So that could be handled at district level or a state level. Then perhaps they may go for 113, is what I'm thinking.
Yeah. So basically, the UAPA Act provides the level of the investigating officer, etc., etc. And similarly, the special acts we saw regarding Makoka or the Gujarat Control of Organized Crime Act provided a level of investigating officer, but the BNS does not provide, which means it will be subject to police standing orders or police manual or any order passed by the DGP or the Home Department, which will decide what will be the level of the IO. And similarly, there will definitely be some guidelines issued based on which it will be decided by the Superintendent of Police whether BNS should be invoked or UAPA should be invoked. So I think we should just wait for a few weeks once this comes into force for all these things to settle down. I think we can take the session forward.
Yeah. So now talking about differences, this is one of the most important aspects of UAPA, which is currently not available in BNS, but of course it's subject to future legislation, of course. But then that is punishment for raising funds for terrorist act. So section 17 of UAPA criminalizes terrorist financing. Now, when you are investigating a terror act, no terror act can be perpetuated without financing, because you need money to buy IEDs, you need money to buy stuff that you require to conduct a terror act. Now, it may be true that you are not able to find terror financing in a particular case, but it is not that terror financing does not exist. So in a small way or a big way, even self-financing of a terror act is still financing. So suppose I buy gunpowder and I buy potassium nitrate, sulfur and other things from Amazon, which is readily available, and mix it and then get gunpowder. I am myself financing the terror act. So now this aspect is currently not there. But then when you're investigating terror act under section 113 of the BNS, nothing prevents you. If you stumble upon this evidence for this section, you can always invoke section 17 of UAPA. So now what I have done is, in the years of investigating cases, I mean, NA has a big database. I have just culled out the MOs that we see, and I want to briefly discuss that, so that when you see these signatures, you should be able to identify that terror financing exists. One type of MO that we have been able to discover is foreign funding of terror through crypto channels. Now in this picture you will see that in between there are 3 bulbs. These are crypto traders. The left side is actually existing in crypto. The right side is UPI transfers. So what happens is, the PIOs, the foreign intelligence officer suspected, sends money, USDT, Bitcoin, Ethereum, and whatever, so to the crypto trader in India. And in turn, that crypto trader has to give back some money, Indian rupees. So what this guy says is, he gives the phone number of the person who is on the right side, right? So now you understand the MO. I hope many of you will be able to
So
understand.
basically, the person in the middle may or may not know what is it for.
He
He's in
has
the
no
dark.
knowledge of the overall scheme of things. He thinks that the left-hand guy, the Pakistani guy, is actually giving his own phone number, but actually he is giving the phone number of the guy on the right. So now, look at the complexity of this case. The right-hand side details will be discernible in the bank statement. अगर आप बैंक स्टेटमेंट को पूरा खोजेंगे तो फिर ये लिंक आपको मिलेगा, लेकिन उस बैंक स्टेटमेंट में लेफ्ट लिंक नहीं मिलेगा आपको. लेफ्ट लिंक के लिए आपको दूसरे क्रिप्टो प्लेटफॉर्म में जाना है, और क्रिप्टो प्लेटफॉर्म के रिप्लाईज को लेकर के ये दोनों को जोड़ के फिर पूरा पिक्चर निकलेगा. सो दिस इज अ वेरी, नाउ दिस हैज बीन इंटेंशनली डिजाइन्ड so that law enforcement agencies cannot actually cover the entire thing so fast. Now this is a very straightforward, ये अपना crypto wallet का address दे रहा है, and he says please send money to this. So this is a straightforward. And of course somebody is saying narco भी भेज रहे हैं. Yes, I will come to that. ये narco का, ये मुंद्रा केस का एनालिसिस है. Whatever I am giving you is only a nutshell. सिर्फ वो टेरर फाइनेंसिंग एस्पेक्ट में दिखा रहा हूं. तो इसमें देखिए आप डबल साइड जैसे बैंक्स में यूज करते हैं. वी रेडेड दिस प्लेस इन दिल्ली, बलीमरान, और उसमें जो भी पैसा उनको आता था, राइट हैंड साइड में क्रेडिट और लेफ्ट हैंड साइड में डेबिट, सभी अरबिक में है. देन it is converted into dollars and it is sent back to Afghanistan. So this is hawala transactions. This is one MO. और इसमें देखिए, in the recent Lashkar-e-Taiba hand grenade case, the topmost fellow Faratullah Gauri is a designated international terrorist. मतलब भारत सरकार ने, there are 2 types of proscription. One is of the organization, that is under Schedule 1. Another is of the individual. Since 2019, we are also proscribing individuals. So individual proscribed terrorist is actually sending money, and it is coming to the last link, the dark green portion at the last of the flow chart. So now all the links in between were painstaking efforts of the organization. हर हवाला operator के पीछे एक और था. So you go and catch hold of him, he will give you some other name. Like this, 10 to 11 levels you go, and you will be able to reach to the top. This is a very typical MO also in terror financing. अब ये PFI का तरीका है. So they are giving written instructions to the cadres saying no more receipts than 5,000. मतलब अगर 5,000 से ज्यादा किसी को receipt नहीं देना है, because they are getting money from elsewhere and they want to fill it up in the form and then show it as genuine money. And this is another signature we were able to see. All these intermediaries, InstaMojo, e-billing, RappiPay, all these are intermediaries where you could actually give the account number of the beneficiary without giving any KYC details of yourself. This market is highly unregulated. तो जब हमने इन्वेस्टिगेशन के दौरान हमने InstaMojo e-billing का डिटेल मांगा था, but they were saying we don't have it because server crash हो गया, because we are not mandated by law also. So these are some of the challenges that you are going to face, but these are some of the, and this is a typical letter from a Maoist case. Communication between a Maoist leader to one of the frontal organization leader, cryptically written, ये तेलुगु भाषा में है, saying that money is required there. And these are some of the searches we conducted. And in one of the cases, we again got organization name. हर कैडर का ऑर्गेनाइजेशन नेम होता है और उनके बाजू में लिखा जाता है कितना मनी देना है. So what I'm trying to show in a nutshell is terror financing can exist in all of the ways which have been discussed now and in ways which we have ourselves not seen. So I'm just trying to educate you into understanding that financing is also an important aspect which you should look in a terror case.
Yeah. So basically, sir, the takeaway will be that even though terror financing has not specifically been mentioned in the BNS, that should not stop us from exploring this. And it would be a very good evidence to actually prove the terrorist act or the terrorist organization in itself. In the BNS, we do have, if you possess property which has been derived or obtained from commission of a terrorist act or etc., then we can invoke, but we should not shy away from invoking section 17 of the UAPA Act as well,
Correct.
which is specifically for terror financing.
Which you do nowadays also.
Which
You
we do.
invoke section 302 with NDPS.
NDPS, yes.
So there's no bar on that. So similarly, what is existing in UAP Act, you can actually investigate offenses by societies or trusts. When PFI was investigated upon, it was a society registered under the Societies Act, and when we investigated this organization, see, you should understand one thing. जो भी ऊपर के लेवल पे बैठते हैं, they are called the National Executive Council members. You cannot expect that these guys, the ideologues, will take a sword and go and kill people. But उनका सिर्फ organization, एक environment provide करना, पैसा देना, वही होता है. So now, when you dig deeper into these organizations, you will understand that money will be going for ostensibly legal and publicly stated objectives. यानी वो ये बताएंगे कि बच्चों को हम पढ़ा रहे हैं, फिजिकल एजुकेशन क्लासेस कर रहे हैं, इसके लिए पैसा खर्चा कर रहे हैं. But in between the statements, you will also find money actually going to terror, people who are involved in terror acts. So after a lot of investigation in PFI charge sheet, we have been able to prove that the organization actually has been funding many of the persons who are involved in UAPA offenses.
Yes, sir. So actually, this kind of answers one of the questions by the participant, which is why has the word only organization been used? And is it the same as terrorist organization UAPA? It is not exactly the same, because this organization actually covers a wide gamut of societies, clubs, etc., etc. So though the UAPA had a specific section that dealt with it, I think the subclause 5 of the BNS kind of covers all of this, where it need not be a proscribed terrorist organization, any organization would.
These are left to the interpretations by court. Now, I cannot tell today how it will be interpreted.
Yes.
Now, we will have to wait and see. But then one thing is for sure, change is the only permanent thing. अब ये कानून, नया कानून आया है, and इसमें intention ये है कि ये normally we start registering these cases. You should understand that any special organization or any special unit in the state also cannot handle all the offenses under that particular genre. So that the local police only can deal with it.
And sir, if we can take this one question, if we invoke both BNS as well as UAPA, then which procedure we have to follow, BNSS or procedure of UAPA?
UAPA का procedure अलग नहीं है, because if you are doing searches is what is divided, what is given in CRPC before, Now it will be BNSS. So the procedure and first part of the presentation I showed you that BNS and UAPA, how similar they are. Whatever sections are there in BNS are actually part of the UAPA. Now we are discussing what is in UAPA but not in BNS. So I think it is all certain sections have been included in BNS and the procedures will remain the same. And anyway, even if you invoke BNS and UAPA together, let me remind you, principle of double jeopardy, no court can punish the accused under both the sections.
So if
मतलब
it's,
ऐसा नहीं है कि आप 113 भी लगा रहे हैं और 16 भी लगा रहे हैं और कोर्ट दोनों में सजा देगा, ये नहीं होगा.
yes. So basically, if we invoke 113, then some offense which is not there in BNS but there in UAPA, like terror financing, can only be invoked.
And
but
what we are discussing right now.
yes, and so we cannot actually invoke 113 and the 16 of UAPA, which will be double jeopardy. Then I think the 16 of UAPA will kind of prevail and the provisions of UAPA will kind
Correct.
of apply. Okay, sir.
So now I'm now moving ahead with some of the administrative measures and powers with the courts and power with the central governments which are mentioned in UAPA Act. 24 May, 25 of UAPA is the enabling provision where the head of the organization, DG NIA as far as NIA is concerned, DGP of the state police as far as the state police is concerned, can attach any property under 25 of UAPA. So now if you have registered a case under BNS and you are saying that some property is identified which is purchased from the proceeds of crime or which is actually used in the commission of an offense, irrespective of whose name that property is registered. ये ध्यान में रखिए, ऐसा नहीं है कि accused के नाम पे ही वो register होना चाहिए, ऐसा भी नहीं है. Proceeds of terrorism is very clearly defined in section 2G that it can be in anybody's name. But if suppose that particular room or house was used for storing the explosive substance, that can be also attached under 25 UAPA, a very effective tool. And I suggest that you start the investigation with 113, but nothing prevents you from using these sections also, is my opinion. सेक्शन 33 यही पावर कोर्ट के पास भी है. जब आपका चार्जशीट लग जाता है तो उसके बाद आप चार्जेस फ्रेमिंग के बाद 33 ऑफ यूएपीए एक्ट में आप प्रॉपर्टीज अक्यूज्ड के प्रॉपर्टीज को अटैच कर सकते हैं. नाउ इन दैट सिचुएशन इट इज नॉट नेसेसरी दैट दैट प्रॉपर्टी इज इन्वॉल्व्ड इन द ऑफेंस आल्सो. These are the properties which are in the name of the accused. So these features, just know it. अभी आप यू कैन जस्ट मेक अ नोट ऑफ इट एंड कीप इट. कहीं ना कहीं फ्यूचर में इस तरह का सिचुएशन आएगा तो आप इसको इस्तेमाल कर सकते हैं. So now in one case where we found the proceeds of sale of heroin, somebody was mentioning narco terror भी काफी हो रहा है. So what we did is we analyzed that one part of the proceeds of heroin was going to finance Hizbul Mujahideen in the valley. The other part was actually going to Dubai for being invested. And the third part of the property, the proceeds were actually going for purchasing land and other movable, immovable properties. Now in this case, what will you do? इसका तो 17 में आएगा ही आएगा, लेकिन जो lands and movable immovable properties खरीदा जा रहा है, why these fellows are purchasing land? One is heroin को छुपाने के लिए, because they will dig the land and then bury it and then seal it. This is a very common thing in Punjab. And land appreciates, so it is inflation adjusted. अब फ्यूचर में लैंड बेच के वो पैसा वो टेररिस्ट एक्ट में डालेगा. So for all these lands, you can actually attach them under 25 UAP Act. Nothing prevents you from doing that. This is one of the sample orders of the DGNIA sealing a property which was used for running terror camps. अब जिसको भी template चाहिए future में, don't hesitate to call us. We will supply you with how to pass these orders. That is all available with NIA.
What about the parallel between 107 BNSS and UAP Act, sir? If you can elaborate a little bit on that.
In
Attachment of.
So see, that attachment is a common attachment which is available in BNSS. Now this attachment of 25, it goes deeper because the property need not be in the name of the accused at all.
Okay.
That is why in NIA's attachments you find random guys coming and the owner of the property saying that मेरा नाम FIR में भी नहीं था और चार्जशीट में भी नहीं है, फिर भी मेरा प्रॉपर्टी को क्यों अटैच किया आपने? क्योंकि आपका प्रॉपर्टी इस्तेमाल किया गया था टेररिस्ट एक्ट के लिए, कमीशन ऑफ टेररिस्ट ऑफेंस. सो देयरफॉर वी हैव अटैच्ड द प्रॉपर्टी.
So I think this is another important point which also partially answers one of the questions. What should we take into account before deciding whether to invoke BNS or UAPA? Could be one that. That's what, ma'am. So there was a question which said that because the explanation says that the SP decides whether to invoke BNS or UAPA.
So
what are the materials?
to put it in nutshell, I am here to tell you how to deal with terror acts. Now उसमें BNS से आपको जवाब देना है तो दे दीजिए, या UAPA आपको लग रहा है कि कुछ सेक्शंस उसमें इस्तेमाल किया जा सकता है तो फिर go ahead and do it. So that, I mean, knowing is, you can use it later on whatever way you want. Similarly, 43D is another enabling provision provided in UAPA, which I think may come in the future, but currently not available, where in BNSS, further investigation is allowed, but in 43D, the after 90 days of time, PP के report के मुताबिक 90 days से 180 days तक investigation time बढ़ाया जा सकता है. This is one of the important advantages that we have under UAPA. Similarly, 43D5, the provision says clearly that special court which is, or the trial court which is hearing the bail petitions, see, look at the word used, shall not be released on bail. That means अगर prima facie case आप establish कर पाते हैं तो the discretion to grant bail is removed by the section 43 capital D subclause 5 of the UAP Act. So in BNS, you may have to file a charge sheet in 90 days and it will be viewed as any other offense. So similarly, one more feature of UAPA which may come in the future is protection of witnesses. When I say protection of witnesses, I'm not saying witness protection in terms of how to keep him away from being attacked. Isme I can move a petition at the time of charge sheeting under clause section 17 NIA Act and section 44 of UAPA, asking the court to declare certain witnesses, witness number 1, 2, 3, 4 up to 30 witnesses, whatever witnesses, as protected witnesses. Once the court passes that order, I will completely redact their statements. कहीं उनका नाम नहीं दिखेगा, एज नहीं दिखेगा, और उतना ही नहीं, आप उनके स्टेटमेंट्स में भी अंदर जाके, because if you simply redact the name, अब स्टेटमेंट के कॉन्टेक्स्ट पढ़ने से पता पड़ जाता है. Say you can say I am a mohalla, I am staying in this mohalla, I am the area secretary. तो उससे पता. So that also you can redact, and you can supply the redacted copies to the defense under section 207 CRPC. मतलब furnishing of copies के time पे. So that is one of the important features of UAPA. And 45 UAPA, there is a sanction which needs to be obtained from the central government, which is not mentioned in BNS Act. मतलब आपको कहीं गवर्नमेंट के पास सैंक्शन के लिए भेजने का जरूरत नहीं है, but then it is all because here you have an oversight of the government also. They go through our evidences, and it is actually referred to a committee by the MHA, and the committee goes through the entire charge sheet, I mean the material available on record, and they satisfy themselves and then say, okay, I give you permission to go ahead and charge sheet him under these sections. This is not there as of today. Now 5 minutes left in the discussion.
So one of the questions is, can Section 18 of UAPA be invoked on any person for doing a terrorist act, even if the person is not a member of any terrorist organization?
That is what I'm telling. You don't have to be a member of a terrorist organization to do terror act. अगर ऐसा होता तो आप देखिए this act will be counterproductive, because the fellow will say मैंने bomb फोड़ा है लेकिन I am not member of any of the organization which you have banned. So it is not like that. Any individual member who does a terror act is liable to be punished. Conspiracy is also applicable. If 2 or 3 persons, all the persons who are not available in the SOC but who have contributed in other ways will be punishable under Section 18.
So are there any more questions? If any more questions are there,
Anybody wants
please.
to ask, or I mean, you can switch on your mics and then ask.
You can raise your hand and we'll switch on the mic if somebody is interested. And again, I would like to request all of you that please go through these 3 sections, that is organized crime, petty organized crime and terrorist act, because they are relatively new for most state police forces, and it is important for us to understand how to invoke them properly. Otherwise, within a few months, I think there'll be a lot of strictures passed and it may be watered down by the court. So I think it's important for us to take this seriously.
See, any change comes with its effect. So the next few months will actually show us the way in the future also. But as of today, this is where we stand.
So there have been a lot of questions and remarks being in the chat box, sir. So since you have experience both as a local police officer as well as an investigating officer in a specialized agency, what do you think about the effectiveness of 113 in dealing with terror cases?
See,
at the state level?
the proof of the pudding is in the eating, and I feel that it's a very good first step, but it all depends on how much we use it in routinely. So it should become a part of our daily activities. That is the intent of the legislature. So if that happens, definitely it will be effective.
Yeah.
And there's another question on
yeah.
cyber. Cyber terrorism is dealt under 66 capital F of the IT Act. So if you find any cyber terrorism kind of an activity using cyberspace to perpetuate terror, invoke 66F. 66F of IT Act is also a scheduled offense of the NIA.
And I think when it comes to whoever conspires, abets or attempts or advocates or incites, directly or indirectly facilitates, I think even in the cyberspace, we'll be able to invoke if they
Definitely.
abet. So I think that section can be used. Someone is accused of having committed offense under clause 7 of 113 BNS, which is possessing a property derived from commission of a terrorist act. Then how to freeze that property?
Freeze means you have provisions under BNSS.
BNSS, that is 107
Yes.
BNSS, I
Yes.
think. And I think if you are invoking BNS, then 107 BNS should be done with the permission of the court, and I think recommendation of the SP or the commissioner of police, as the case may be. So I think that is the answer to that question. And I take this opportunity to thank you, sir, for sparing your valuable time. And I think you have brought not just 113 of BNS, but a lot of UAPA Act as well. And participants would have definitely learned a lot about UAPA Act as well. And I'm sure that this session has been very useful to them, brought some insight, and has also pointed them in the right direction into what are the other steps or reading that they have to do with respect to effective invocation of 113 Bharatiya Nyaya Sanhita. So I think we can take a 5 minutes break. Yeah. So we'll take a break of 5 minutes, and then we'll come back for the ultimate session of this 2-day module, where we'll be taking some feedback and some takeaways from these 2-day module. I thank you again, sir. Thank you.
Thank you.
Good afternoon, everybody. We are now finishing, we are at the fag end of the conclusion of the entire 2 day program on the new criminal laws. As a part of takeaway, we do not have basically too much to give away, although we are very much interested in looking into a lot of feedback to receive from you. But we have been at our end in NP doing something, so I just wanted to show it to you. It's not working. Okay. We have come out with the what you called e-content on iGot, which is about all three new criminal laws. So we are being uploading it. CRPC BNS is ready, and so it will be uploaded in today or by tomorrow. BNS and the BSA portion will also be uploaded, and it is basically being done in coordination with NALSAR. And with Nalsar, as you can see, we have they are just the screenshots of it, which we have developed on a very simplistic way. And this entire portion is more or less about how circumstances we are going to be having, like about zero FIR. It is in a very simplified manner, and we believe it would be very much useful to the ground level. So this is basically in a question answers format. So similarly is that of the BNS also, and we are also coming up with the Bharatiya Saksha Adhiniyam also. This is the last portion of it, which I wanted to formally introduce to you, is something which NPA has, which is the knowledge management system. So knowledge management system is hosted on our website. It is there on our NPA website as well as this independent website, where there is this entire manual of how do we actually approach it is also, and I have uploaded that in the drive also. The most important point is that anybody can enroll here, and anybody will be enrolling at this point. If you do enroll, you can enroll in this .net or .gov.in. You can enroll yourself in knowledge management system, and once you're enrolling yourself in knowledge management system, all the PPTs of NPA will be available to you. So now we do have, and I'll be sending this on the drive. The links to the drive are also there, and I'm once again putting it on the group also. But apart from that, I'll request each one of you, each and every one of you, to be basically try to enroll in this knowledge management system. Yes, you do require a government login, any government login, GOV, whether it is your respective state governments. Once you register, it will generate a password by itself with that email ID. And once you are doing with that email ID, the password gets generated, and then you will have access. We'll be moving the recorded portions of these sessions also onto that forum for you to be accessing it at a later point of time, at any point of time when you are going to be requiring it. New criminal laws is a new paradigm for us. It is a lot of new challenges as well as a lot of new powers for us. So it is extremely important for us to understand how we will eventually develop ourselves in those domains. This is just this feedback link I have already shared in the group, so I'm not sharing it here. I'll once again share it in the group. So my last request to all of you will be to please upload the feedback in the feedback form, as well as now we can formally keep it open for any suggestions, any sort of suggestions that any one of you has. I think we can now share it and discuss it also. So we'll switch it. Anybody who wants to enable कर दीजिए किसी को भी. Anybody who wants to talk can be enabled. आप unmute करने का ही. If you have submitted the feedback, thank you so much. I'll also be submitting you this drive link again. Please note the drive link and download all the PPTs from that. This last PPT is not there. Other than that, all PPTs are already uploaded. We will upload all other PPTs also. Is there anything that any one of you would like to share? Sorry. So sorry, I just forgot to switch it on. So basically, if you have formally joined the joining formalities, you have filled up the joining formalities, we have your details, and we will be able to send you the details or the PPTs also on email. Other than that, we will not be able to send any emails to individual Gmail accounts. We will all request you to go to the KMS only, and then do definitely log in for the KMS also. So thank you so much from everybody and anybody. But I'll once again, I'm fully filling the even the joining instructions part also. I'm once again putting it. If you have not filled it up, please fill up the joining formalities. Otherwise, we will not be able to be in a position to share with you the PPTs. I think that's it from our side. Thank you so much for joining. Thank you so much for listening for the last 2 days. And we hope that we were able to help in this journey of improving our understanding about the new laws. Thank you so much. Thank you so much. Please do remember to fill the feedback forms. Please, once again, requesting all of you to please fill the feedback forms. Thank you so much. So if you have filled up the feedback, sir, you can definitely leave the room. And thank you so much for joining. Thank you, Arunachal Pradesh Police, also for requesting us and helping us in this entire collaborations. On behalf of Director NP, also we thank one and all for this entire process. And thank you so much. If you have, my only sincere request is please fill the feedback form. It's extremely important for us to improve. So please fill the feedback form.